Welcome to today's program titled December 2024 CTA Update. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During this presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you received. Copies of this program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker. Justice, you may begin.
Good afternoon and good morning as applicable. I'm Justice Barber. I am a partner on the real estate team in the Atlanta office of Seyfarth Shaw. And as my colleague just mentioned, the CLE code and information will be at the end. And for any of the early registrants, please note that this session has been, this will be a 30-minute session. Tricia?
Yes, hi, I'm Tricia Macaluso. I'm a partner in the Dallas office of Seyfarth. I'm a commercial litigator. And given the recent events in the last week with regard to why we're all here today, I was asked to come on and talk about the litigation piece of the CTA. Trevor?
Hi, my name is Trevor Tullius. I'm a partner in the Institutional Investor Practice Group based in our DC office. And, before we talk a little bit about the nationwide injunction issued last week, we wanted to do kind of a quick overview of kind of what we're talking about and what's at stake. If you go to the next slide. So essentially, kind of what is the CTA, the Corporate Transparency Act of 2020? And it became effective at the beginning of this year. And of course, the purpose from the legislation and from FinCEN was to protect the U.S. financial system from illicit use and bad actors. And simply put, the CTA seeks to get disclosure to the government of entity ownership to prevent money laundering. As most of you already know, filings are made with a federal agency, the Financial Crimes Enforcement Network, which is based in the Department of Treasury. Next slide. So who would be required to report? Well, reporting companies are both domestic and foreign entities that, unless they're covered by an exemption, are registered or created to do business in the United States by filing a document with a Secretary of State or other kind of similar office with tribal nations or with a government agency. So really this would be corporations, limited liability companies, limited partnerships, statutory trusts, entities not really covered by the CTA are those not required to file formation documents with a state entity or operational documents with a state entity such as sole proprietorships, general partnerships, and common law trusts. So now I'll toss it to Justice to talk a little bit about some of the high-level exemptions.
So there are several exemptions to this, but we caution you that what they are loosely called does not necessarily mean what you think it means. There are lots of specifics about these exemptions. There has been additional clarity and Q&As released by FinCEN to help people conduct this analysis. So one of the important exemptions is for regulated entities. So again, as we mentioned, we're really we're trying to protect against financial crimes and bad actors. So for entities that are already regulated, you're already filing reports with the SEC, or you're a bank, a credit union, other public utilities, as you see here. I won't read the whole slide to you, but that is the nature of this particular entity. Of this particular exemption. And we note that for any exemption, if your status changes, there would have been 30 days to make your filing as applicable once that exemption went away, because you do not make a filing if you're exempt. And then on the next slide, you'll see that some of the other common exemptions are for large operating companies. So generally, that entity would have to have 20 full-time employees in the United States with a physical office in the United States, which they could lease. They don't have to own it. You also would have had to show on your filed tax return that for your prior year, that it was $5 million in gross receipts or sales from the U.S. sources. So, you know, there are some hurdles to jump there, but that's a very, very common exemption for a lot of our clients. There are also exemptions related to tax-exempt entities and sometimes subsidiaries of certain entities that qualify for some of these exemptions, or inactive entities. And you'll see here on the slide, we've noted that the exemption for an inactive entity is very narrowly defined. So it doesn't just mean, oh, this entity that's out here that's barely doing anything. There are important considerations. But as you all know, these exemptions, we're not going into details about the exemptions because of the recent judicial happenings. But Trevor's going to tell us about the key filing dates, just so you understand the buckets that were here for these in case filings have to be made.
Sure. Thanks, Justice. So, you know, why are we talking about this in December of 2024? Well, it's essentially because the filing deadlines that were in place before last week are coming up very, very soon. So, you know, if you had an existing entity that was created before this year, the filing deadline for that would be January 1, 2025. If you created a new entity this year, you had 90 days after that entity was formed. So, you know, for many folks on this call, you may have already filed a report. Maybe you did it via the PDF, or maybe you did it online through FinCEN's website. We found that was actually rather straightforward, that people found that to be pretty easy once you got all the necessary information. You know, we wanted to remind folks, like Justice did, that any updated or corrected reports that you needed to file this year or in the future will need to be made 30 days after the change or the discovery of the, you know, inaccurate information. You know, there's a deadline. The deadlines apply to exempt entities that maybe lose their status as an exempt entity in 2024. And then, you know, just as an FYI, in 2025 and onward, the deadline would be 30 days. So that's a much quicker deadline than folks have been used to. But, you know, as what we've all been kind of processing over the last week, I'll toss it over to Tricia to tell us kind of why all these are stayed at the moment.
So, you know, why now? Why December? This case, in particular, Texas Top Cop Shop, that's a mouthful to say quickly, got filed actually back in May of this year. So it's not like this lawsuit got filed in the last month. It got filed back in May. And as is per usual, sometimes with our federal courts, it's taken a while for its requested relief of preliminary injunction of the enforcement of the CTA to make its way to an opinion from the court and for them to give its guidance. And so that all happened on December 3rd. The Eastern District of Texas court issued its preliminary injunction. The effect of that order is nationwide. It prevents the enforcement of the CTA, meaning that Trevor just told you all these deadlines. They're saying, no, you don't have to comply with those right now. That's not enforceable against you. We are issuing a preliminary injunction that stops any enforcement action related to a failure to comply with those deadlines or the requirements of the CTA in any way, shape, or form. So given that, what did the court consider? What were the arguments? You know, just know this is not the first time the CTA has been challenged in the federal court system. It has been challenged in other courts, in other circuits, but any injunctive relief that has been awarded, if at all, was limited to the parties that had sought the case, not a nationwide one. And in other cases, it was denied completely and that the CTA was found to be constitutional. Here, the principal issue before the court was whether or not it could be enforced due to constitutionality. The constitutional challenges raised by the plaintiffs in this case were that the CTA violates the 9th and 10th Amendments by intruding upon states' rights. I think I've heard more about states' rights in the last year from the federal courts than you typically would hear, or that we've heard in, I don't know, 100 years, but it's back in the hopper of a theory of why things should or shouldn't be enforceable. The other is the CTA compels speech and burdens your right of association under the First Amendment. And the third ground was that the CTA violates the Fourth Amendment by compelling the disclosure of private information. The court analyzed these issues, examined whether it had a valid exercise of Congress's power under the Commerce Clause and the Necessary and Proper Clause. The court concluded that the CTA does not regulate an existing activity, but rather compels a new one, that we have to now send in the information and provide the information that's required by the CTA, and that is a new requirement. And the court found that that exceeds Congress's commerce power. Finally, the court concluded that the CTA is not justified under the Necessary and Proper Clause in conjunction with Congress's power to regulate foreign affairs or to lay or collect taxes. Now, note that this preliminary injunction is preliminary in nature. It is a temporary order of the court, but in doing so and in issuing it, the court has found that the plaintiffs demonstrated a substantial likelihood of success on the merits of their claims, and that the plaintiffs would suffer irreparable harm absent the injunctive relief. So that is, in a nutshell, the 80-page opinion with the highlights, if you will, about what was considered and why. The court did not reach the ultimate conclusion that the CTA is unconstitutional. Rather, this is a preliminary finding that the plaintiffs would be, or they do believe that the plaintiffs have a substantial likelihood of being successful on that. But until that ultimate issue comes down, there is no finding per se of unconstitutionality. So with that, on December 5th, the Justice Department, the Justice Department on behalf of the Department of the Treasury filed its notice of appeal. The court then filed an amended memorandum opinion, did not change the substantive outcome, but an amended notice of appeal was also filed on December 6th. So what happens next in that regard from a procedural standpoint? Now that they have filed their notice of appeal, that will proceed before the Fifth Circuit. It'll be assigned judges. They'll have a briefing schedule. All of the normal trappings of an appeal will occur pursuant to the federal rules. However, it is anticipated that the government will seek some type of expedited appeal, given its most recent filing yesterday, where in the Eastern District they filed a motion to stay preliminary injunction pending appeal. That is, they're basically saying, hey, court, we realize that you've just issued this preliminary injunction, but we're really going to be hurt by that, and you need to stay that application pending our appeal to the Fifth Circuit, because we're going to appeal it. They also advised the court in that filing that if the court does not rule yesterday or by today, that they will likely seek that exact same relief from the Fifth Circuit either today or tomorrow. And they were very explicit with their dates, December 12th and December 13th. I have checked the dockets, and as of starting, I see that nothing has been filed and no opinion has been rendered. So stay tuned. I'm sure something will happen in the next 2 days that will give us some insight as to procedurally what they're going to try to do next with regard to stopping the enforcement of, or stopping rather the application of this preliminary injunction. Of course, last week when this happened, everybody was like, what's happened? What are we going to do? Do we do it? Do we not do it? Is this, because everybody recognizes this is just one case, that they recognized that it was going to get appealed. What do we do next? And everybody was wringing their hands, kind of, waiting to see what was going to happen next. the Financial Crimes Enforcement Network, or FinCEN, and for those of you who have been in the process of preparing your disclosures, that you know who FinCEN is because you can get a FinCEN number. But FinCEN did weigh in. FinCEN is the enforcement arm. They would be the ones that would go after you for failure to comply with the CTA. And FinCEN did issue an alert basically saying, we're aware of it, we know it's happened, not complying with the January 1 deadline is okay at this point, we're not going to come after you. So, I mean, you can see the reading here. The alert provides that in light of that, they're not going to be subject to liability if they fail to do so while the order remains in force. That's key, given what I just told you, that they have sought a stay of that preliminary injunction. So, it's very much in flux. We know FinCEN's intentions. They've been out there. They're on paper. But we also know that the DOJ has not dropped this. They are continuing to pursue it. But this DOJ will change in January. And what happens at that point, is anyone's guess. That being said, as far as whether this is a plot, I want to remind you also about this. This is only for federal enforcement. Like every state that has its own reporting requirements can continue to do whatever it does for its state. This has absolutely no impact on state reporting requirements. So to the extent that a state has a reporting requirement similar to the CTA or not quite as onerous as the CTA, but has its own reporting requirements or desires to pass its own reporting requirements, it can still do so as of today. This case does not impact that as it stands currently. But the tea leaves going forward, I don't know, Trevor?
Yeah, no, Tricia, I want to ask you, other district courts have said the CTA is constitutional. And so I think that's an interesting fact that's out there, is that there's just one specific court that has enjoined, enforcement nationwide. 40 days from now, we'll have a new administration that was, hostile to the CTA when it was first passed in 2020, vetoed an appropriations bill initially because this, for one reason being the CTA was included in that appropriations bill. Thinking about the timeline, how long do these cases last? Like, what could possibly be done for this specific injunction between now and maybe a hearing at the Fifth Circuit in the next 40 days before, the leadership at DOJ changes?
Well, it's as they said and as they have indicated, if the district court here does not issue a stay of this preliminary injunction, they're going to seek that relief from the Fifth Circuit. The Fifth Circuit it is within their purview to grant a stay of this preliminary injunction pending the appeal. However, the way this is postured is, this case is one where the plaintiffs and the court ultimately have reasoned that they will be harmed if they have to disclose this information, and that is what it's preventing from occurring. And if on appeal, if the Fifth Circuit were to say, okay, we'll stay the injunction while we consider the constitutionality or the appropriateness of this ruling, the cow is out of the barn at that point, because then you would have to be complying with the CTA pending any rulings by the Fifth Circuit. And it effectively nullifies the entire lawsuit and its purpose. That's not to say the Fifth Circuit couldn't or wouldn't do that, but the Fifth Circuit is traditionally a pretty conservative district, and I would anticipate that, I don't have a crystal ball. They could do it. I doubt they'll do it in the next 40 days. Continue on. The appeal will take time. Appeals take a long time. They can seek an expedited appeal. That's an opportunity. That's something the government can also do. They can ask the court to rule on this quickly. But again, there's still a briefing schedule. Both sides get to weigh in. I anticipate there'll probably, amicus briefs or amicus, depending on what part of the country you're in. There'll be briefs filed in support of one side or the other as to why it's important or not important, or why it shouldn't move forward. But appeals last a long time, 2 years. It could go a while. It'll be well into the next administration probably before you see an ultimate resolution. And then if you end up with a split among the circuits, then you'll see it probably tracking its way on up. Next slide.
So
Jesse?
what this means for everybody on this call. So while right this moment, as Tricia explained, Fenton's made it clear they're not going to take any enforcement action against anyone that's not making a filing by this January deadline. What we are encouraging our clients to do is to complete your analysis for all your entities. Understand that if this injunction were not in effect, would you have had to make a filing? If you did, or did you satisfy the terms of an exemption? If you did have to make a filing, do you have all of the information that you would need from all the parties to make that filing? So our advice is to at least have completed your analysis and understand whether you would have needed to make a filing, whether you might have satisfied the criteria for one of the exemptions, and then to document and save. And I'll mention, even if you satisfy an exemption, it's not that you're making a filing about the exemption and how it is that you satisfy it, right? So you just need to, but it is very important that you document and you save in your company records why you reached the conclusion that you reached. So you should do that. The other thing is, as some of you know, you spent a lot of time this year tracking down folks for personal information, driver's licenses and other items, or you were encouraging folks to get a Fenton identification number so that you could use that number in your filing instead of the information. And to the extent that you've determined that you would have ordinarily been responsible for making a filing, and the folks that you would need this information from are, internal or otherwise, they were already prepared to give you this information or give you their Fenton identification number, we think you should go ahead and gather those to prevent scrambling last minute if this does change. I mean, as we've just said, while it's unlikely that a stay will be issued, it's not impossible. And so we're not necessarily suggesting that you're going out to partners and, these third parties who you've been asking 8,000 times already, and they just do not want to give you this information because they will absolutely raise this development for you. But to the extent you can have that information, we really encourage you to do that. The other reason why it's important to document is, as my colleagues mentioned earlier, you may find yourself subject to a state-level similar rule that you'll have to comply with, and you'll want to have this analysis. It'll be different under those rules, but your basic information that you had to gather about who owns and controls your entities will be very important. And if you had determined, and I know some of you guys have already made filings, a lot of you, I'm sure, in fact, please keep in mind that if you made a filing and this changes and it becomes live again, if you made a filing and your information has changed, you need to file you will at that time need to file an amended filing within 30 days. If you had determined that you had an exemption, so you wouldn't have made a filing, but this becomes a requirement again, and you lose that status, you will have to do a filing at that time. And so to the extent you can, finish your analysis, keep everything documented, keep it in your record. So if this doesn't, as Tricia said, it could be 2 years from now, somebody else might be responsible for doing this. So it'll be a good practice.
One other point just to raise to make everyone aware, Justice is absolutely right. I mean, it's better to be ready than not. In this particular instance, it's the safest course. Because I will also tell you that one of the additional or alternative reliefs sought by the Department of Justice on this stay issue is they say, fine, if you don't want to issue a stay on the nationwide injunction, can you at least revise the injunction to be only as to the parties in this case? That would be more consistent with the way it's been handled in other courts thus far. So that is an out for the Fifth Circuit to take, or even this court to take, if they were so inclined. And in doing so, then it's like it's game on once more for everybody else except the parties to the suit. So that is a more likely scenario than an outright stay in total. But again, I don't have a crystal ball, so we'll see.
As you'll see here, the QR code that was mentioned at the beginning is up for you to scan and walk through the steps to get your credit. I will, excuse me, I will call out the attendance verification code that you'll need to complete this. It is SS, as in Seyfarth Shaw, 3422. Again, that was SS 3422. And we're going to leave this up so that you all have an opportunity to scan this, and not going to take it down too fast for you, but we've got a lot of questions here. We're going to try to hit a few of them. And I think we've kind of alluded to one. A really common question is, if you have an exemption, do you have to file? And again, I think we might have mentioned, if you have an exemption, you're not filing your exempted status, you just do not make a filing. But you need to keep your documents and your analysis behind that in case an inquiry comes up in the future. You will want to be able to show that you had really thought about this, that you made a reasonable assessment, that you've documented everything, and not that you got an inquiry about it and then you all of a sudden want to say, oh, I'm exempt, and that's why I didn't make a filing 2 years ago, whatever. And again, if you were exempt when you did your analysis, and you didn't make a filing, but things change, so this injunction is lifted fully, or it's lifted in a way that only the parties in the case are the ones that don't have to comply. Please remember, if your status changes, you need to file an amended, well, if you lost an exemption, you'll need to make a filing. And that's true in the perpetuity. You're not making this analysis one time, right? You need to continuously be checking this, so make sure you've got procedures in place. And if it changes, you need to make the filing. If this becomes live again and you are making a filing and it changes, your information changes, again, you need to file an amended, you need to make an amendment to that filing. And I will put in a plug for FinCEN identification numbers for people who will be doing this frequently, because once the number is in there, if it's just their personal information that's changing, you don't have to change your filing. But if you
right.
submitted, what'd you say, Trevor?
No, I was going to say that that's absolutely right. That's the easiest way to do it. There was one other question that I wanted to get to, because I know we've got about 90 seconds left.
Thank you.
And it's, if an ND is already filed, do we need to require to make updated filings while the injunction is in effect? And I think the answer to that is no. You might want to, as Justice just mentioned, keep that information handy, but the answer to that is no. Another question is there any way to undo a filing that you made at FinCEN earlier this year? The answer to that is no. There's not an option on the FinCEN website to delete a filing. You can replace a filing with a new filing, but you can't delete an existing filing. And so that's, if they've already got your information, they've already got it. And FinCEN, once this is all settled, I know will come out and tell us what they're going to do with it. But that's unknown at the moment.
Like we stuck to 30 minutes. So yes, good job.
Yes. Oh, sorry, one more here. So we're not, just to be clear, we're not suggesting that you make a filing right now if nothing changes. We're just suggesting that you're prepared to make a filing if the status changes. But you can file if you want to. That
Okay, I think that's all we have. Thank you all for your time this afternoon. If you have any questions, feel free to reach out to any of us on the webinar or your Seyfarth relationship partner. We're happy to talk through any other questions you have.
Absolutely. Thank you all.
Have a great day.